first one is State of Ohio versus John Smith. And the panel has read the briefs and ready to proceed, but we just need to go over a few ground rules. First of all, all the attorneys are asked to stand behind the podium and to keep your voice up because we are videotaping. And we also ask not to use the names of victims or the names of any children, minors. Just refer to them as either the victim or the child or their initials, something along that realm, just so that on the video they won't be identified. Each side will have 15 minutes to present their arguments. Now I know with you, we only have you arguing, so you'll have your full 15 minutes. Ordinarily, you'll be able to save some rebuttal time and so forth. But other than that, I think we're ready to proceed.
Good.
Thank you.
Thank you. I will approach.
And the monitor over there has the time, but quite frankly, I don't use the rebuttal. I just use the 15, so when you stop, that's what you have like this top number.
Thank you very much.
And I just paused it for you, Mrs. Stark.
May it please the court, it's a pleasure to be here this morning on behalf of John Smith, Attorney Donald Pott. We recognize it's problematic, and we recognize that fact that Mr. Smith had a warrant for his arrest that night. Our contention is that this court should not consider that outstanding warrant because the fact of that warrant should not have been known. It was not brought out at a suppression hearing. The parties did not engage a suppression hearing in this action. Instead, they submitted the 2 officer body cameras as evidence in support of their positions of the suppression issue, but they had no testimony from the officers. They only stipulated to the authenticity of those videos. So I say that because the scene, at the scene of events, clearly we have a driver without violating the traffic law. And the officers are conducting the stop pursuant to that, conducting their investigation pursuant to that stop. But the officers engage the passenger and request identifying information merely because the passenger was not wearing a seatbelt. There was no other reason stated on the video and during the stop as to why the officer may engage the passenger for his identifying information. So our contention is that this court should not look to the fact that there was a warrant for his arrest, which obviously would subject him to the search, which the contraband's in his pocket. Instead, the officer decided to talk to Mr. Smith and inform him that the officer was asking for identifying information because he wasn't wearing a seatbelt. The problem with that is the car had already been stopped for almost 4 minutes by the time the officer saw Mr. Smith without a seatbelt. Our contention is that the vehicle is no longer being operated. So if there was a seatbelt violation, it had already occurred. And again, we're not assuming anything that there is a seatbelt violation, but had there been a seatbelt violation, it had already occurred. The passenger sitting there, the car is not being operated at that point. So he disengages his seatbelt, which is what he tells the officer at scene.
Could you explain to me, because I'm not sure I'm following, I'm disregarding the outstanding warrant, like you said.
Okay, thank you.
purposes of this
Right.
question. So the driver's taken out, then they go over and start talking to the passenger. And in speaking with the passenger, like you said, they realize or they comment that he's not wearing a seatbelt. And you said that had already occurred, so I'm not sure I understand why that would prevent the officer from citing somebody for not wearing a seatbelt, because it had occurred. If it had occurred, it occurred already, and it was done. I'm not sure I understand what you're saying.
Well, what I'm saying is the officer didn't see that. The officer didn't see the misdemeanor offense. And so, and I looked at the video of both officer camera videos, and the cameras are on the chest and the eyes are above the chest. So I'm not sure, the angle. We can't tell from the video whether the officer, when he approached the driver, was able to see Mr. Smith without a seatbelt. I was trying to see that, and I could not. And that would have been helpful to know, but the parties waived the suppression hearing. There was no testimony, so we don't know what the officer saw himself, other than our viewpoints on the body cameras. And and we don't know if they had planned, or if it was routine for them. And it may be routine for the officers to conduct that investigation to have all of the passengers in the vehicle to identify themselves. That's usually what I see normally. However, we don't have that here. And absent that testimony, that's a fact that has been assumed into the record. And we can't assume that that's what would have occurred. Now, had that been testimony at the suppression hearing, then I may not be standing here today, because that would have been inevitable discovery of the fact that he had a warrant and then the search incident to arrest. So we don't have that here.
Let me ask you, whenever, and obviously we'll be able to see this in the record, hopefully, anyway, that it's in the record, but when they stipulated to the admission of the two body cameras, the video and the body cameras, was there a stipulation that that is all accurate as well?
Yes.
Okay.
Yes.
So you don't have some evidence coming in, like you were saying, testimony, but there is at least, both sides have stipulated that the information on the body cameras, whatever the officer is saying and so forth, is correct.
I'm pulling up the transcript of the suppression hearing. Attorney Laybourne, defense counsel, indicates it's page 3. We would stipulate to the authenticity of State's Exhibit 1. So I took that to mean that the body cameras are true and accurate depiction of what is on the videos. So, and the state conveys the same thing, prior page 2. We're agreeing that these body cams, in this case of the traffic stop, there's 2 body cameras, and we'll stipulate to that it's authentic. So is that what you're driving at there? You're asking whether it, I guess they didn't agree that what happened really happened, but they're...
Well, here, let me give you an example.
Okay.
Officer approaches the car and he says, please tell me your name and your social security number. And he says, I don't have to. Okay. And officer said, well, I see you're not wearing a seatbelt. And he says, I took it off. And the officer said, yeah, but I saw that you didn't have a seatbelt on before you took it off, whenever you were originally pulled over, when the driver was originally pulled over. Do you think with that stipulation, this is what I'm getting at,
Yes.
would that testimony that the officer said, or not testimony, but that statement be accepted as valid or as true?
Well, it would be accepted enough for the misdemeanor citation.
Okay, so
Yes.
anything that's in the video, the body cam, you're saying with the stipulation that would mean that whatever statements the officers made were credible? That's kind of important, that's the reason why I'm
Well,
asking.
there was no testimony.
I understand.
You know, and I think that the state bears the burden to show that testimony. And they decided not to do that, maybe because it's a small case, it's an F5, they don't want to waste the court's time, and they're in a hurry, and other matters on the docket, but that was not brought out in testimony, so.
Thank you.
Yeah, thank you. And I went through enough of the semantics definitionally of being operated in the brief. I don't know if I need to belabor that. I tried to convey that is something now and in the future rather than in the past. And so with that, I would waive any further presentation unless the court has other questions.
Well, no, it doesn't look like we have any further questions. Thank you so much for your presentation.
Thank you for having us, it was a pleasure.
your report this morning. And the matter will be taken under advisement and a written opinion will be issued and will be sent to both sides. But you can also check the Supreme Court website if you're anxious.
Thank you.
Because we'll release it electronically. Thanks very much.
Have a good day.
Have a good day too.